Hello, welcome. We're here today with the Honorable Michelle Harner, bankruptcy judge for the District of Maryland. Our subject today is some history and progress of Subchapter 5. And Judge Harner is a perfect person to be talking about that because of two important roles that she has filled. The first one is back in the 2012 to 24 time frame. She served as the reporter for the Commission for the Study of Chapter 11. And then this past year, she served as co-chair for the Subchapter 5 Task Force. And both of those efforts coming out of the American Bankruptcy Institute. So welcome, Judge. Great to have you.
Thank you so much. I'm honored and excited to be here. And I'm glad you mentioned both commissions because I'll just do my usual caveat that I'm here for educational purposes only, and nothing that we talk about can be used against me in my courtroom.
All right. Duly noted. Before we get into the Subchapter 5 topic, though, what does the reporter of a commission do?
So, the reporter is an interesting position. It's typically filled by an academic. So, back in 2012 to 2014, when I was working with the Chapter 11 Commission, I was on faculty at the University of Maryland Francis King Carey School of Law. As you know, most recently, Professor Alex Sickler served as reporter for the ABI Subchapter 5 Task Force. And it's a wonderful role for an academic because we do three key things. First, you are kind of the one who organizes, facilitates, and then documents or records all of the meetings, hearings, and deliberations of the commission or the task force. So in that role with the Chapter 11 Commission, I got to sit in on all of the field hearings, and we did 16 in the context of the Chapter 11 study. We had 13 advisory groups working with us who had wonderful chairs and advisory members, and I got to sit in on their meetings, deliberate with them, and then of course deliberate with the commissioners and record all of their discussions and help facilitate the conversation to make sure we were covering a wide area of the law, Chapter 11, since its inception. The second thing we reporters do is we are in charge of all of the research, or organizing and coordinating the research. And so it's a wonderful position to learn more about the field we're in. And I learned a tremendous amount in both experiences, both as a reporter for the commission and then in working with Professor Sickler in Subchapter 5 and our study of that particular piece of legislation. And then finally, perhaps the heaviest lift for the reporter is drafting the report. And so I think it's most times, I can't speak for all groups who use reporters, but most time the reporter is the one that puts pen to paper first and does that first draft, and then works with the commissioners or the task force members to refine and really finalize the document for publication that would represent the kind of work product of the entire project.
Cool.
Yeah.
So you do the hard work for the commission.
I think both Alex and I would tell you it's a labor of love.
Well, there you go. All right. All right. So now into Subchapter 5. So what effect did the work of the Commission for the Study of Chapter 11 have toward the creation and enactment of Subchapter 5?
No, that's a great question. So I will tell you, so first I brought props. So these are the two commission reports, the Subchapter 5 report and the original commission on Chapter 11 report. And at least for me personally, when I went into the Chapter 11 study, I was thinking mega cases, traditional Chapter 11 cases, and the issues we had been seeing in the changing landscape and dynamics of Chapter 11 cases. But what came out of our study, and in particular the field hearings, was a real concern about how Chapter 11 worked for smaller companies. So much so that one of the three key findings of the commission is stated in the report as follows, and it's the second one the commission noted. Second, the witnesses who testified on issues relating to small and medium-sized enterprises generally opined that Chapter 11 no longer works for these companies. Witnesses cited cost and procedural obstacles as common barriers. And so it was through the 16 field hearings and the witness testimony, both oral and written, submitted to the Chapter 11 Commission, that the commissioners felt strongly something had to be done. Fortunately, the Chapter 11 Commission that was formed and supported by the American Bankruptcy Institute wasn't the first organization to recognize that small businesses are such a huge component of our reorganization scheme. And in fact, I always credit Judge Tom Small, who was in North Carolina and really started to innovate with how to get small businesses through Chapter 11 on a more efficient, on a quicker timetable. And so he had worked with the National Bankruptcy Conference in 2010 to put forward some legislation. And then, as I like to say, Don, the stars kind of aligned in 2019. The NBC had this historical work. The Chapter 11 Commission had put forward its recommendations on SMEs. And the ABA also had done some work in this area, and everyone came together to help our small businesses. And the Small Business Reorganization Act of 2019 was the end product. So it has a great history. I think the Chapter 11 Commission played an important role, particularly in energizing the conversation in 2019. And I'm proud to be a really, 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 really small part of that.
Well, I think it was a little bit bigger than that, but on to the next question. So based on the past year of task force studies, what do you see as the main benefits of Subchapter 5?
So I don't think this will come as a surprise to anything done, but I thought what really stood out in our study of Subchapter 5 is what everyone hoped the subchapter would do. It's made small business bankruptcy cases quicker, cheaper, and more effective, right? So when I think of why we've heard from so many quarters, right, judges, practitioners, business owners, that Subchapter 5 might be the best thing enacted in the bankruptcy space since the 78 code, I think it's because the process established by the subchapter really does work well. Not perfectly, right? Nothing's perfect, but it works well. And so we're seeing cases file. They're put on a pretty quick timeline because there's no mandatory creditors committee, although someone can request a committee, but there's no mandatory creditors committee. There's no required disclosure statement. There's a lot of cumbersome, costly aspects of a traditional 11 taken out of the process so that the timeline's quicker, the process is cheaper. And then because we've formulated what I think of as a modified absolute priority rule for small businesses under Subchapter 5, they're actually able to confirm Chapter 11 plans. And, we looked at a lot of data, Don, when we were studying the subchapter. And I think as of February 2024, over 7,500 companies had filed for Subchapter 5. Well over 50% of those companies are confirming Subchapter 5, Chapter 11 plans. And the number that I think is most telling about the subchapter is of the plans confirmed, over 60% are consensual or 1191A plans, which mean they had creditor support. So I know everyone's still learning the subchapter and still figuring out how it balances the rights of debtors and creditors. But I think we're getting there, and I think people are finding a way to make the subchapter work, and it's working quicker, it's cheaper, and it's more effective.
All right. Well, so then what do you see as parts of Subchapter 5 that need to be changed to make it even better?
So, that's an interesting question, Don. And I feel like we should be having this conversation together because you were in all of the deliberations as well, and you know where the Sub 5 task force for the ABI came out. And so pop in at any point if you have additional color or would disagree with kind of where I feel the task force ended up. But my sense of where we collectively came out at the end of our 1-year study is that, you know what, the subchapter is working well. It's early, right? We've only had it in place for 4 years. I think we were cautious not to recommend too many changes that might have unintended consequences. I got the sense that people felt it's working. Let's not make change for the sake of change. Let's let the courts and the parties figure this out collectively. So we only really recommended change where there seemed to be a real problem that time might not facilitate a meaningful resolution that would benefit all parties. And so when I think about the few areas of change that we recommended, I would highlight two, and then I'll give you a third, just I think general concept for people to be aware of, that I think was at the heart of our study. But the first change that I think is important is to figure out how to either get more parties engaged in the confirmation process or allow our Subchapter 5 debtors to confirm an 1191A plan when they have an unengaged class. And of course, here, Don, I'm talking about the silent class problem, right? That in a small business case, you may have a class of creditors that's properly classified under Section 1126, but for whatever reason, none of the creditors in that class submits a vote. So they're not objecting to the plan. They're not rejecting it. They've just decided, probably on a cost benefit analysis, it's better just to do nothing, or maybe they're not sure what their rights are, so they do nothing, but there's nothing from that class. And so you may have 4 classes of creditors saying, yes, we support this plan. We've submitted our votes in favor. And then you've got 1 class of creditors who hasn't voted. And you have a debtor looking at confirmation and saying, gosh, I've got this one silent class. And because of that, I might have to do an 1191B confirmation, where that means the trustee may have to stay in place and make distributions, which can be costly. I'm not going to get my discharge until the end of the plan commitment period, which has to be 3 to 5 years under 1191B. And there may be other delay in my reorganization. It's not the kind of everyone singing kumbaya around the fireplace that we hope for under 1191A. And when the task force looked at this problem, they really felt that it was an impediment to a reorganization that would benefit everyone, probably even those creditors who weren't voting. So the recommendation, as you know, Don, from the task force, is that we basically create an approval process under 1191 when there is a silent class that lets the court give 1191A benefits to confirmation if the debtors can show that all of the other requirements of 1191B that are intended for the protection of creditors are satisfied. So has the debtor put forward sufficient evidence that it is committing all of its projected disposable income to the payment of creditors, including the creditors in that silent class? Is the plan fair and equitable? Is it appropriate and not likely to be followed, by another need for reorganization? You think about all of the protections in 1191 and 1129. If all of those are satisfied, other than the fact that we have this silent class, the court could, under the task force proposal, do an 1191A confirmation, which then gives an immediate discharge, gets the trustees, like you serve as a Subchapter 5 trustee, gets you off the hook, eliminates that cost of the dispersing agent, and just allows the post-confirmation life of the business to begin sooner. And that can be important for a business, right? To get out of that bankruptcy mode and into a post-confirmation renewed kind of business life. And so that's the hope of that proposal. So I think that's an important one, because I don't think, given the current statutory structure, it will resolve on its own. I think that one would benefit from a change.
Yeah, and I remember when I first became aware of the issue, it was about the 3rd case I was in as a Subchapter 5 trustee, and we'd negotiate, the parties had negotiated resolutions to all the objections, and everybody that voted in favor of the plan, and we come up to confirmation, and somebody says, well, it's a non-consensual confirmation. I says, no, it's not. Everybody's on board. And they said, well, somebody didn't vote. Some class didn't vote. I said, well, they don't care. And frankly, they don't have any basis for objecting. But yeah, that's not a consensual plan. And so so I'm 100% on board with this.
Yeah. And I'll note here, as we're just suggesting this for Subchapter 5, right? I know it can be an issue in a traditional 11 as well, but that may need a different fix, different kind of dynamic, perhaps. But right now we're focused on Sub 5. The other change I will note is that the task force recommended a statutory change to require a one-time post-confirmation report by the debtor at the end of the implementation of the plan. So after substantial consummation in an 1191A plan or the end of the payments in an 1191B plan. And basically the report would just give the courts and creditors information regarding how the debtor did, right? Were they able to fund the plan? Did they get the payments out? And I think that's important not only for informational purposes regarding the effectiveness of the subchapter, but I personally like it as an accountability measure for the debtor, right? The debtor has to come back to the court and say, yes, I did it, or no, I didn't. And I think having a debtor know that they still have some remaining reporting obligation to the court can be helpful because we don't want the debtor to get that confirmation order, get the discharge, and feel like it's now free to do what it wants. It still has some responsibilities, and I think the reporting can help underscore that. I know debtors counsel tries hard to underscore those messages, but sometimes a court requirement can help. So that's the other statutory change I would highlight. There's a few more in there, so I recommend this lovely book to folks. You can get it online in PDF, and it's now user-friendly PDF, so you can click on a link and go right to the section. It's at abi.org. But Don, the last point I'll say about the report that I hope comes through is the task force desire to help educate, right? I got the sense, I think the task force collectively got the sense when we were working through our hearings and all of the materials, that a lot of people just don't understand the Subchapter 5 process yet, or haven't really thought through how the subchapter works in the overall bankruptcy scheme, right? What tools are available to the parties? What rights do the debtors have? What rights do the creditors have? And I think there's more to the subchapter than most people have come to appreciate at this early stage. So I'm hoping that the task force report encourages people to learn more about the subchapter and think more innovatively and meaningfully about their rights under the subchapter. Because I do think it tries to balance debtors and creditors' rights, even if it changes the playing field a little bit from the traditional Chapter 11 or the traditional small business Chapter 11 case. So that would be the other thing I would point out, that I'm hopeful that people will learn something from the Subchapter 5 Task Force report, and that we all continue to learn collectively as we move forward under the subchapter.
Well, okay, so there's one thing I want to make a plug here, and then maybe give it back to you for some additional comment, and that is on the debt limit. There's a $7.5 million debt limit for Subchapter 5 eligibility that currently exists. On June 21, there will be a sunset to that law, and we'll go back to like a $3 million eligibility number. And a bill is pending right now to extend that for a couple of years, the 7.5 million. And that is consistent with the task force recommendation on that issue. Could you address that just briefly?
Sure.
Issue?
So, yeah, no, I think it's an important issue. And I think there is some important data out there regarding the debt cap. And, it's at 7.5 million now for maybe a little more over a month, unless Congress acts, because it does sunset on June 21st. And so we did a lot of work, as you know, Don, around that issue, because we knew it was timely, that we only had a certain amount of time to get information out to everyone about how the subchapter was working under that debt cap. And what we found is, of those 7,500 Subchapter 5 cases I mentioned earlier, over a third of those are above the original 2.75 million debt cap, which means if the debt cap sunsets, a good chunk of companies would no longer have the Subchapter 5 reorganization tool available to it. A third of 7,500 is a lot of companies. And so I think it's important to recognize the subchapters being used by businesses over 2.75 million, or the 3 million as adjusted for inflation, and that the subchapter is working for those companies. So the data also shows that if a company right around the $7.5 million debt cap files for Subchapter 5 reorganization, they double their chances of confirming a plan as compared to traditional Chapter 11. So again, just speaking from the data, when I look at it as a former academic, I'm like, well, the numbers make sense. We've seemed to somehow hit the sweet spot with the 7.5 million debt cap. And although, as you know, Don, it originated right around the time of the pandemic, it was, I think, increased in March of 2020 when we were all kind of at the very early stages of the pandemic. And although that's its origins, at least based on my reading of the data and the cases I'm seeing, I don't think the debt cap is linked to the pandemic. I think small and medium-sized companies face financial distress all of the time, whether it's because of inflation or an economic downturn or a product that's become obsolete or a change in their business model. They face financial distress. And when they do, the traditional tools of Chapter 11 just do not work at that debt point. And so a debt cap reflects the complexity of a case. 7.5 million seems to be exactly the right spot for Subchapter 5 in this moment. And I say in this moment because, as you know, Don, people testified before the Subchapter 5 task force and they wanted it at 10 million or 15 million. And of course, there were people who wanted it lower as well. But I would say most folks coalesced around that 7.5 million debt cap limit, which aligns right with the data. And I'm hoping that people take an opportunity to read our preliminary report and the supplement to that on the debt cap, as well as the final report, because there's a lot of good information in there about how to think about the options and what might be best for the system.
Well, thank you. Thank you, Judge Harner, for not only being with us here today and sharing your thoughts, but also for the superb and important work that you've done on both the Subchapter 5 Task Force and on the Commission for the Study of Chapter 11. We are indeed indebted to you for that. So thank you.
Well, thank you. And thank you, Don, for your service on the Subchapter 5 Task Force and for your blog, which is so informative and helpful. And I appreciate you having me on today.
Thank you.